What's up, party people? It's your favorite neighborhood lawyer, Markwell Cade with Cade Mark Law, back with another resource for you. Before you participate in any inherently dangerous activity like skydiving or bungee jumping or going to a trampoline park like Defy Gravity or Monkey Joe's or any of these types of things, usually you must sign what's called a prospective liability waiver. Generally speaking, they're just called waivers, but that is the legal term for them. So today, we're going to talk about 3 things you should be aware of about these prospective liability waivers. The very first thing you should be aware of about these prospective liability waivers is that just because you sign one doesn't mean you can't sue. I have a lot of clients that come to me with an injury or something that's occurred as a result of one of these activities, and they think that they can't sue because a lot of the language in the waiver that they sign talks about their inability to sue and creates this language which makes this expectation that deters them from suing in the first place. Typically, this is what waivers are used for. They're acted as a deterrent to prevent you from suing, to make you think that you don't have a case because you signed something that says, I won't sue. In some cases, this will be upheld and you won't be able to sue. But in others, just because you signed something that says, I will not or cannot sue, doesn't mean you can't. Which leads us to the second thing that you should know about these prospective liability waivers. They usually only prohibit your ability to sue for risks and dangers and injuries that are inherent or that come with the activity that you're signing the waiver for. For example, if you're at Defy Gravity, there's a chance that you could roll your ankle in just the normal course of jumping around and having fun. This is a danger or an injury that is inherent in that activity. You can't then sue Defy Gravity if you roll your ankle just jumping around in their facility. But on the other hand, if one of their employees drops a 20-pound weight on your child's head while they're jumping, this is not an inherent danger that comes with jumping around at Defy Gravity. This is something extra. This has gone past that point. And at that point, Defy Gravity won't be able to prohibit your ability to sue with this waiver, as that's not a danger or an injury that can come from that activity. Finally, you should also be aware that for some states, this prospective liability waiver will be invalid every single time. In Virginia, for example, they've struck down the use of prospective liability waivers. They say, yes, there are some activities that are dangerous and there are some injuries and dangers that can come with these dangerous activities, but we're not going to allow companies to shirk the responsibility if these people were to perform these activities and get hurt. This means that you should check your state's laws or consult with a lawyer in your state on whether a prospective liability waiver that you signed is even valid in the first place. That's all, folks. Thank you so much for joining us today. This has been 3 things you should be aware of about prospective liability waivers. Once again, I am Markwell Cade with Cade Mark Law, your favorite neighborhood lawyers. Protect your brand, grow your business. Stay frosty, my friends. We will see you next time. We hope this was helpful.